Hi, my dragons. Part 2, week 2, psychology and law. Okay, so another example would be SCM versus Xerox. Out of 84 potential jurors, 22 had jobs that were relevant to the case, and they were dismissed, because that's another flaw that the law assumes, that if you know something about the case at hand or information presented in the case at hand, that you will bias all the other jurors, so you're out. So instead of giving the case to experts in the field, they want people who don't know anything about it. They assume that your head is just empty and they can educate you on antitrust just by a few expert witnesses. And we as psychologists find that to be preposterous. And if anything's going to bias a case, not knowing anything about the subject is going to bias the case. So those of us who do research in this area find that to be really funny and odd, okay? They think that bias can be brought into the jury box, and what they realize is that, no. So cognitive psychology works with these types of things, processing complex information, and it's really very interesting. Another example is death qualification. So in order to sit on a capital jury, you have to be death qualified. In other words, you have to say, sorry, I got the hiccups. In other words, you have to be willing to give the death penalty. So when they're screening potential jurors, they ask them, would you be willing to give the death penalty if the evidence merits it? And if you say no, then you are excused. You are called a Witherspoon excludable, or a juror that will not give, the death penalty. They call you death scrupled, okay? But research from cognitive psychology and social psychology shows that if you commit to something before actually doing it, you are much more likely to do it, okay? And we call that the confirmation bias. So the question then becomes, is it fair to the defendant then to exclude death scrupled jurors, okay? So this has always been a real sticking point, and it came through on the Witherspoon case, Supreme Court case Witherspoon, where they got the whole ruling of excluding people who were death scrupled, okay, who could not under any circumstances give the death penalty. So they call them Witherspoon excludable. So we know from cognitive psychology that we have a confirmation bias working there. Other differences, and perhaps the biggest argument between clinical psychology and research psychology, is the issue of memory. And when you look at forensic psychology, eyewitness testimony, memory, and expert witnesses, those are the oldest and most researched topics in all of forensic psychology. And it creates a huge controversy in forensic psychology, okay? So clinical forensic psychologists, clinical psychologists in general, say that trauma and stress produce repression and suppression. And people actively try to forget painful events, okay? They even try and disassociate it. I'm not saying that that's not true, because I was trained in clinical psychology as well as forensic psychology. So we just have to find the balance. But experimental psychologists and research psychologists, especially research forensic psychologists, have a different concept of memory. And the most prolific person who does research on this is someone named Elizabeth Loftuson. We're gonna talk endlessly about Elizabeth Loftuson, her research. She has done so much work on the researching memory and false memories that she wrote a book, and her book is titled Eyewitness Testimony. And it's considered one of the Bibles of forensic psychology. And I do have that book in my office as well. So you can go to any library and look for it, and it's just a huge compendium of all the research cases that have been done in eyewitness testimony. And basically, Elizabeth Loftus does a very good job of providing solid evidence for the fragility and malleability of memory, okay? She's a leader, distinguished psychologist, okay? So clinical psychologists say that repressed memories are repressed because it's too painful for people to think about them. So they repress them and they keep them buried deep down inside. And only sometimes can memory be triggered, and it can be never be triggered, or it can be triggered by some odd thing in the environment, or lay dormant for months, weeks, days, years, whatever. And this all has to go back to how people handle traumatic events. And we know that there is a lot of research that supports this as well. So we have to look at memory and trauma and suppression and the active memory, not in terms of two things that are contradictory, but in terms of a complexity and how they come together. Okay, so that's really, really interesting. Clinical psychologists are very adamant in the belief that suppression is real, suppression exists, and it influences recovery. I myself have even testified before the Ohio Supreme Court and other places testified, and have worked on cases where, look, people have had trauma, and you must expand. I did it for expansion of the statute of limitations for child sexual abuse, because adult survivors of child sexual abuse, they didn't come forward as kids and say, hey, this happened. They waited until something triggered their memory, and then they came forward, and people accused them of only being in for it for the money. And so recovery, that's not the way recovery works. And on the other hand, research forensic psychologists such as Elizabeth Loftus argue that memory is malleable and suggestible, and we change our memories, and they're not dependable or reliable, so we shouldn't oftentimes place great stock in memories. So all of that comes into play when we get to the courtroom, because the jurors are sitting there, well, who should we believe, the clinical psychologist or the research psychologist? And believe me, that happens all the time in a court case, and each side is saying, their truth, their research, what their research is showing. So it can become very difficult for jurors in a courtroom listening at things like that, okay? So cognitive psychologists, and we're going to talk about memory. There's a whole thing we're going to talk about eyewitness testimony and expert witnesses. But for the purposes of this today, we're just looking at the historical concepts and the things that shape forensic psychology and the controversies that we have between psychology and law and forensic psychology. So know that memory is a huge sticking point in forensic psychology, and we're still working on coming up with an adaptable solution for both parties. Other things that go on is our very knowledge about eyewitness testimony and how cognitive psychology works when that gets to the courtroom. So just get ready to hear a whole bunch of things like that. We have to talk about implicit theories. One of the things I asked you in your bio is to tell me what your implicit theory of forensic psychology was. And implicit theories are theories that we believe in. They're a theory. We don't have usually statistical or research evidence to back up our implicit theory. Many times they're accurate, but a lot of times they're not accurate. It's our own biases, the way we think about the world, the way we think of things are right or wrong, or things like that. So simply asking people to come into the courtroom and lay these biases aside is difficult, because people bring that into the courtroom, okay? So again, here is a point in forensic psychology that offers a wealth of information through research about implicit theories and implicit biases that we all bring into the courtroom. So attorneys have to be aware that this is another area where forensic psychology can help the law. And for those of you who are forensic psych majors, probably everybody in this class, if you ever get called for jury duty, I was called for jury duty, can you imagine? They called me for jury duty. And they said, what do you do for a living? And I say, I'm a forensic psychologist. And they say, can you be unbiased in a court? And I was like, let's talk about the word unbiased. Let's talk about the empirical realization of that word and what we think that means. And then I start going on and on about forensic psychology and implicit biases, and they all go, get her out of the courtroom. You're not going to be on a jury. That too will happen to you. You go in there and say, I have a bachelor's degree in forensic psychology, and then, it's all over right there. So anyway, implicit theories is another way where psychologists can help the law. Here's another big one: insanity and competence to stand trial. So psychology, this is our thing, right? We don't have any such word as insanity in the DSM. I dare you to go look it up. It is not there. And it takes forever and ever and ever for people to understand psychology. You have to go and get a PhD or PsyD or some doctoral level thing in psychology or psychiatry. And, you're studying, mental illness, diagnosis, development, manifestations, therapy, psychopharmacological stuff, neurological stuff, everything. It takes a long time to understand this. So you're not going to understand it in the course of one trial where they think that we're going to bring in an expert witness and they're going to tell you about mental health. Okay, if it were only that simple. It's not that simple. And the courts have realized this in recent years, which is why we have mental health courts. Okay? So the law has a very, very, very poor record and a very poor system of understanding insanity, mental health issues. Okay? They just don't get it. So this is another reason why we have mental health courts and things like that. Let's complicate this. Every state has different insanity laws or insanity rules. Again, we are not the United States. We're the not United States, especially when it comes to laws. Okay, what's legal in one state is illegal in another state. How can you ever expect to mete out justice when you have different laws over different things? So insanity is a big sticking point. Okay, insanity and mental health laws are not uniform, and you can't have someone doing the same crime in state A and as state B, but state A has this penalty and state B has this penalty for the same exact behavior and be in the United States. See, that is inherently unjust, okay? So it is the single biggest roadblock to developing justice and services to a population like mental health population. The United States needs a uniform system of justice when it comes to everything, but especially true for mental health issues, okay? And, the legal term for, psychosis, which we have so many terms and so many different classification and diagnoses and everything. But the legal term is insanity, and we don't just look at insanity. It's much bigger and much broader than that, and it's very complicated. And so that's what I mean by the law needs to get its act together when it comes to mental health. And they're trying with the mental health laws and stuff like that. But you cannot bring someone in and have an expert witness testify, even on one diagnosis, never mind the whole enchilada, and expect jurors to understand that and to make a decision based on their little bit of understanding from the witness that talks, even if a witness talks for half an hour, it won't be fair. The justice will not be fair for that person, okay? So if you want to really talk about that, look at John Hinckley, okay? John Hinckley, who's in love with Jodie Foster, and he tries to impress her. He has a delusional disorder. He's going to impress her by trying to shoot the president, okay? Versus Jeffrey Dahmer. Jeffrey Dahmer, who, finds people and brings them to his house and has sex with them and then drugs them, or drugs them and then has sex with them, and then kills them and cuts them up into little pieces, puts them in his refrigerator, and then eats them. John Hinckley is insane, but Dahmer is sane. When you put those two cases together, you see how not having a uniform code of justice or a uniform code between mental health law, how that is really detrimental to the United States. You're looking at two separate things. Wisconsin had a different mental health law than a federal health law that was governing John Hinckley, and as a result, you have an uneven system of justice, an uneven system of mental health interpretation, and you have two people serving two different types of sentences for mental health crime, okay? And then, so let's add to this. Wisconsin is a non-death penalty state, okay? So that was something right there. So that's what I mean. When you look at mental health and things that don't mesh with law and psych, there's a good example. Okay, we're going to stop there for part 2, and we'll continue this on the next video for part 3.